If you want to understand how fragile the rule of law can become when power, money, and politics collide, you need to understand exactly what happened inside that Manhattan federal courtroom. Because what unfolded there was not normal, not routine, and not something that can be brushed off as just another dramatic legal moment. It was a line being tested, a boundary being pushed, and a signal sent, not just to a judge, but to the entire American justice system. This did not start with shouting. It did not start with chaos. It started the way some of the most dangerous moments always do, quietly, procedurally, almost boring on the surface. The morning session opened with arguments over evidence, financial records, documents, transactions, the kind of dry material juries often find tedious, but that prosecutors rely on to build airtight cases. The defense objected as expected. Motions were argued. The judge listened. Nothing unusual, and that's what made what came next so shocking. Because behind the scenes, pressure was already building. 2 days earlier, something had happened that most people still don't fully understand. A sealed filing meant to remain hidden from public view briefly appeared on the federal court's electronic system. Only minutes, long enough for legal analysts and court watchers to notice, long enough for screenshots to be saved, long enough for panic to set in where it mattered most. According to people familiar with the filing, it wasn't just more paperwork. It was allegedly a roadmap, a financial trail, communications that contradicted prior claims made by the defense, evidence that, if authenticated and presented cleanly, would seriously damage the core narrative Trump's legal team has relied on from the start. Whether every detail ultimately holds up is something the trial will decide. But the reaction inside the courtroom tells you one thing clearly. The defense believed this evidence mattered a lot. When Judge Caldwell ruled that the full body of documents could be admitted, the air in the room shifted. Observers describe it as the moment the temperature changed. You could feel it. This wasn't just a loss on emotion. This was the moment the defense realized the case had entered a new phase, and that's when the unthinkable happened. The lead attorney stood up, not to object, not to request clarification, not to ask for a recess. He stood up and accused the court of bias. He declared the trial illegitimate. And then, in a move that stunned everyone present, he and his co-counsel physically gathered their belongings and began walking toward the exit. Let's be very clear about how extraordinary that is. Federal courtrooms are not cable news studios. Lawyers are not performers. They are officers of the court. They are bound by strict ethical rules. You do not simply leave because you dislike a ruling. You preserve objections. You appeal later. Walking out is not protest, it is defiance. And the judge understood that instantly. Judge Caldwell is not known for theatrics. She has decades on the bench. She has handled organized crime cases, terrorism cases, complex financial prosecutions. She has seen aggressive lawyers before, but this was different. This was an attempt to collapse the proceeding itself. Her response was immediate and unambiguous. She warned them that if they took another step, they would be held in criminal contempt. She ordered U.S. Marshals to block the exits, and in seconds, armed federal officers moved into position. That moment matters more than any headline, because in that moment, the courtroom stopped being a place of argument and became a place of enforcement. The system asserted itself. For over 7 minutes, no one moved. The defense attorneys stood frozen. Their clients sat in silence. Jurors were not present, but staff, reporters, and officers all understood the gravity of what they were watching. This was not symbolic. Contempt in federal court can mean jail time, disbarment, careers ending on the spot. The attorneys returned to their seats, but the damage was already done. Because the walkout attempt wasn't about persuading the judge. It was about creating a record, a spectacle, a trigger for appeals and political messaging. Within minutes, emergency motions were filed accusing the judge of misconduct. Calls for recusal followed. The defense claimed the threat of arrest proved bias, even though any first-year law student knows judges have absolute authority to maintain order in their courtroom. This is where the strategy becomes clear. By attempting to force a crisis, the defense created multiple future arguments. If the trial ends in conviction, they claim judicial hostility. If the judge sanctions them, they claim suppression. If she allows them to withdraw, they argue ineffective counsel delays. Every path creates noise, delay, confusion, and delay is the real currency here. Because time matters, elections matter, public attention matters, and turning a courtroom into a stage shifts the battle from evidence to narrative, from law to loyalty, from facts to feelings. What made this moment even more alarming is what the judge revealed shortly after. She referenced a sealed submission from prosecutors that morning, an ex parte filing, rare, serious, the kind of thing courts allow only when there are safety concerns, witness protection issues, or national security implications. That single disclosure changed how every legal observer interpreted the walkout, because experienced defense lawyers know exactly what that means. It means someone is cooperating, someone close, someone with direct knowledge. And when you combine that with the timing, just days before major testimony, the picture becomes hard to ignore. This wasn't just frustration, this was fear. Fear that the case was no longer controllable. Fear that a witness could tell a story backed by documents, transactions, and records that jurors understand intuitively. Fear that the defense narrative would collapse in real time. So the question becomes, was this a legal move or a political one? The answer appears to be both. Media crews were already in position outside the courthouse. Commentary began almost immediately, framing the judge as authoritarian and the defense as heroic. Social media messaging followed a familiar script. This was not spontaneous outrage. It was coordinated response. And that is where the danger truly lies. Because when courtrooms become campaign props, the justice system is no longer being challenged from the outside. It's being attacked from within by people sworn to uphold it. Judges rely on compliance to function. They don't command armies. They command respect. When that respect erodes, the system doesn't break all at once. It fractures slowly, through precedent, through tolerated misconduct, through the normalization of behavior that would end any other lawyer's career instantly. Judge Caldwell recognized this. That's why she spoke about shadow counsel, backup attorneys prepared to step in if the defense attempted another stunt. It's a safeguard designed to protect the defendant's rights while preventing manipulation. It is rare, and it is a sign the court believes disruption may continue. This is not about whether Trump is guilty or innocent. That is for the jury to decide. This is about whether any defendant, no matter how powerful, can bend the process itself through intimidation and spectacle. History tells us how dangerous that path is. Every time the justice system is weakened to serve one individual, it becomes weaker for everyone. For whistleblowers, for defendants without money, for people who rely on rules being applied consistently, not strategically. What happened in that courtroom was a test of whether authority would blink. It didn't. But the pressure is not over. The most consequential moments are still ahead. Key testimony, rulings on mistrial motions, decisions that will shape not just this case, but how future high-profile defendants attempt to game the system. And that's why this moment matters, because if walking out becomes a tactic instead of a sanction, the rule of law becomes optional. And once that happens, justice stops being justice. It becomes performance. This was only the opening act. What happened after that failed walkout attempt is just as important as the walkout itself, because once the defense team sat back down, the trial didn't return to normal. It couldn't. The atmosphere had changed permanently. Everyone in that room now understood that this was no longer just a legal contest over evidence and testimony. It had become a struggle over control, legitimacy, and who ultimately decides how far the rules can be bent before they snap. Within minutes of returning to their seats, the defense began executing what many legal analysts immediately recognized as the next phase of a high-risk strategy. Emergency motions were filed at lightning speed, motions for mistrial, motions to recuse the judge, motions alleging prosecutorial misconduct. On paper, these filings looked procedural. In reality, they were laying down landmines for the future. Each motion wasn't designed to win in the moment. It was designed to live forever in the appellate record. This is how modern legal warfare works in cases like this. You don't just argue the facts. You manufacture claims of unfairness that can be weaponized later. You flood the record with objections so that if the verdict goes against you, you can argue not just that the jury was wrong, but that the entire process was corrupted from the start. And by attempting to walk out, the defense created the most extreme version of that claim imaginable. But here's the problem they now face. That tactic cuts both ways, because while appeals courts care deeply about defendants' rights, they care just as deeply about protecting the authority of trial courts. Judges are given wide latitude to control proceedings for a reason. If appellate courts start endorsing lawyer walkouts as legitimate protest, the entire system becomes ungovernable. Every future defendant would have an incentive to create chaos the moment things turn against them, and judges know this. That's why Judge Caldwell's written response later that day was so striking. Her language wasn't emotional, it wasn't defensive, it was surgical. She framed the walkout attempt not as passionate advocacy, but as a calculated disruption. She made clear that the court would not allow proceedings to be manipulated for external audiences or political gain. And she explicitly warned that further attempts would result in sanctions, referrals to bar authorities, and potentially arrest. That kind of warning is not given lightly. Judges understand the gravity of invoking contempt against counsel. They also understand the precedent it sets, but they also understand something else. If they don't draw the line clearly, they invite escalation. And escalation is exactly what many observers believe the defense was hoping for. Because escalation feeds narrative, it feeds claims of persecution, it feeds fundraising emails, campaign speeches, and social media posts declaring the system rigged. And that narrative has been effective before. The difference now is that it's colliding head-on with the mechanics of a live federal trial, where rules are enforced in real time, not debated on television. Another critical detail that emerged later that day added even more context to why tensions were so high. The judge referenced enhanced security measures and the possibility of sequestering the jury. That alone tells you how seriously the court was taking the situation. Jury sequestration is disruptive, expensive, and deeply unpopular with jurors. Judges avoid it unless they believe outside influence or intimidation is a genuine risk. Why would that concern suddenly arise? Because the courtroom is not isolated from the outside world. When legal teams coordinate messaging, when political figures amplify claims of judicial tyranny, when supporters frame judges as enemies, it creates pressure that jurors feel even if they never see a single tweet. Judges are trained to protect jurors from that pressure, and when they believe it's escalating, they act. This is where the idea of a cooperating witness becomes central to understanding the defense's behavior. While sealed filings are, by definition, not public, the mere acknowledgement that one exists and relates to security concerns sends a clear signal to experienced lawyers. Someone is talking, someone with access, someone whose testimony could connect documents, transactions, and intent in a way that is hard to explain away. In white-collar cases, documents tell you what happened. Witnesses tell you why. And when those two align, defenses crumble fast. That possibility reframes the walkout attempt. Suddenly, it looks less like righteous outrage and more like desperation, less like protest and more like a gamble to derail momentum before something irreversible happens in front of a jury. And juries notice everything. Even though jurors were not present during the walkout itself, they returned to a courtroom that felt different. Lawyers were sharper, the judge was firmer, the tone was heavier. Jurors may not know the procedural details, but they understand human behavior. They understand when people are nervous. They understand when authority is being challenged. And studies show that jurors often interpret extreme defense tactics as signals that the evidence is overwhelming. This is one of the great ironies of aggressive legal theatrics. What plays well on cable news can backfire catastrophically in front of 12 ordinary people tasked with deciding the truth. Jurors don't like chaos. They don't like games. They tend to trust judges far more than lawyers, especially when judges appear calm and lawyers appear combative. And Judge Caldwell remained calm. That contrast matters. Outside the courthouse, the reaction was immediate and polarized. Political figures rushed to frame the incident in ideological terms. Supporters called it tyranny. Critics called it an attack on the rule of law. Media outlets chose sides. But inside the legal community, the reaction was far more unified. Former prosecutors, defense attorneys, and judges across the spectrum described the walkout attempt as reckless at best and professionally dangerous at worst. Because lawyers know what this puts at risk, not just this case, but the norms that protect everyone who enters a courtroom. There is also a financial dimension that cannot be ignored. High-profile defense firms carry massive malpractice insurance for a reason. Walking out of a federal trial creates exposure not just to contempt, but to claims of ineffective assistance of counsel. If a conviction occurs and an appellate court finds that the defense intentionally disrupted proceedings, it could open the door to lawsuits from their own client. That's not hypothetical. It has happened before. That explains why reports quickly surfaced of emergency meetings inside the defense firm. Senior partners don't gather late at night unless they believe something has gone very wrong. Careers, reputations, and financial futures can hinge on moments like this. And yet, despite all of that, the defense appears prepared to continue pushing boundaries. Why? Because from a political perspective, losing the legal case may matter less than winning the narrative war. Delay itself can be a victory. Casting doubt on legitimacy can energize supporters. Turning courtrooms into stages can blur the line between accountability and persecution in the public mind. The danger is that this approach assumes the system will always blink first. What happened in that courtroom suggests it may not. Judge Caldwell has signaled she is prepared to keep this trial moving no matter how uncomfortable it becomes. She has tools, contempt, sanctions, shadow counsel, schedule control, and she appears willing to use them. That sets up a direct confrontation between a court determined to preserve order and a defense strategy that thrives on disorder. This is the collision point. Because if the defense escalates again, the consequences will not be theoretical. Arrests of attorneys, once unthinkable, become real possibilities. Disbarment proceedings become real, and the narrative shifts from heroic resistance to professional collapse. At the same time, the prosecution knows it must tread carefully. Overreach could validate claims of bias. Every move is scrutinized, every decision weighed. This is a high-wire act on both sides, but only one side controls the courtroom. And looming over everything is the testimony yet to come. If a key witness takes the stand and corroborates the documentary evidence, the defense's remaining options narrow dramatically. At that point, theatrics become less effective. The jury focuses, the story crystallizes, and the appeals record, no matter how thick, cannot erase what jurors saw and heard with their own eyes. This is why what we're watching is not just a trial, but a stress test. A test of whether the justice system can withstand coordinated pressure from wealth, politics, and media without losing its core function. A test of whether rules apply evenly or selectively. A test of whether intimidation works when applied openly rather than subtly. The next phase will determine the answer. Because if the court holds firm and the process continues, it sends a powerful message that no defendant can hijack the system simply by being loud enough. If the process breaks, the precedent will echo far beyond this case. And that is why this moment matters so much more than the personalities involved. What makes the next phase of this story even more consequential is what happened after the courtroom doors finally reopened and normal proceedings resumed on the surface. Because while it may have looked like order had been restored, beneath that calm was a legal and institutional reckoning already underway. Judges do not forget moments like this, neither do jurors, neither do appellate courts, and neither do the professionals whose careers depend on the integrity of the process. Once court recessed for the day, the signal went out across the federal judiciary and legal community. This wasn't just another high-profile defendant throwing a tantrum through counsel. This was a coordinated attempt to redefine what zealous advocacy means in a federal courtroom. And the reason that alarm bells rang so loudly is simple. If this tactic is normalized, every future trial involving money, power, or politics becomes vulnerable to collapse by spectacle alone. Inside chambers, Judge Caldwell reportedly convened a private meeting with senior court administrators and security officials. That alone tells you how seriously the court was taking what had just happened. Judges don't call those meetings unless they believe future disruptions are likely, and they don't discuss security unless they believe the courtroom itself has become a target for external pressure. At the same time, the prosecution team began recalibrating. Prosecutors are trained to expect aggressive defense tactics, but this crossed into territory where the orderly administration of justice itself was being challenged. That changes everything. When lawyers attempt to physically abandon proceedings, prosecutors begin documenting behavior not just for trial strategy, but for the record. Every outburst, every motion, every act that could later be framed as obstruction or manipulation gets preserved. And here's where the defense may have miscalculated. Because while the walkout attempt may energize a political base, it also gives the prosecution leverage. It allows them to argue that the defense cannot be trusted to proceed in good faith. It strengthens the case for additional safeguards. It justifies closer judicial supervision. And in extreme circumstances, it opens the door to remedies that defendants rarely want, like court-appointed shadow counsel or restrictions on public commentary. Those measures are not punishments, they are stabilizers. And once imposed, they fundamentally change the dynamic of a trial. The concept of shadow counsel is especially telling. Courts only consider it when they believe defense attorneys may intentionally sabotage proceedings. Shadow counsel sits quietly, observes everything, and is prepared to step in instantly if the primary defense team refuses to proceed or is removed. The mere presence of shadow counsel sends a message to the jury that the court expects disruption, and juries interpret that as a sign that something is deeply wrong with the defense's posture. From a defense perspective, that is disastrous. Meanwhile, the media narrative began to split along predictable lines. Some outlets framed the incident as heroic resistance to an unfair judge. Others framed it as an unprecedented attack on the judiciary. But the most revealing commentary came from people with no political incentive either way. Retired judges, former federal defenders, ethics experts, they were nearly unanimous. This was not principled protest. This was brinkmanship. And brinkmanship only works if the other side blinks. Judge Caldwell did not blink. Her reputation matters here. She is not a judge known for grandstanding. She is known for meticulous records, narrow rulings, and opinions that hold up on appeal. When a judge like that issues a warning, it is not theatrical, it is calculated. Every word is chosen with the expectation that it may one day be read by a higher court. That means she is building a record. And records are what appellate judges live on. Which brings us to the most dangerous assumption underlying the defense's strategy, that chaos automatically favors delay, that disruption automatically creates appealable error, that judges will hesitate to act forcefully for fear of backlash. That assumption may have been valid in other arenas. It is far less reliable in a federal courtroom governed by lifetime appointed judges who do not answer to voters or cable news panels. Federal judges have one primary mandate: keep the process intact. And when they believe that mandate is under threat, they act decisively. There is another layer to this that deserves attention, because it goes to the heart of why this incident resonated so strongly beyond the legal world. The attempted walkout didn't just challenge a judge, it challenged the idea that institutions have authority independent of individual will. It suggested that if you don't like the rules, you can simply reject them publicly and dare the system to respond. That is a deeply destabilizing message in a democracy, because courts are one of the few places left where power is supposed to be equalized, where wealth doesn't buy different rules, where fame doesn't confer immunity, where procedure matters more than personality. When that principle is attacked openly, the damage isn't confined to one defendant or one case. It ripples outward, eroding trust in the entire structure. That's why international observers reacted so strongly. In many countries, lawyers who attempt such a stunt would be immediately detained, not because the system is authoritarian, but because the authority of the court is non-negotiable. The idea that attorneys could threaten to abandon proceedings as leverage is almost unthinkable in functioning judicial systems. The United States prides itself on due process and adversarial fairness. But adversarial does not mean anarchic. There are boundaries. And those boundaries were tested deliberately. As the night went on, attention turned to what might happen next. Would the defense double down? Would they attempt another provocation? Would they leak selective narratives to friendly outlets? Would they replace counsel entirely in an attempt to reset the process? Each option carries serious risk. Replacing counsel mid-trial is not a clean reset. New attorneys inherit the existing record. They inherit prior rulings, they inherit the jury's impressions, and they inherit the court's skepticism. Worse, sudden withdrawal by current counsel could itself be framed as abandonment, raising constitutional issues that again cut both ways. This is why seasoned lawyers describe the defense's position as self-inflicted peril. They have created a situation where every path forward is worse than the one they were on before the walkout attempt. And looming over all of this is the testimony yet to come. Witnesses change trials, especially witnesses with inside knowledge, especially witnesses whose accounts are supported by documents, especially witnesses who were once close to the defendant. When such testimony arrives, juries listen differently. They stop thinking in hypotheticals. They start connecting dots. That is why timing matters so much here. The defense's dramatic move occurred just days before key testimony. Not weeks, not months, days. That suggests urgency, and urgency in a courtroom rarely signals confidence. As Monday approaches, the pressure intensifies on everyone involved. The judge must rule on pending motions. The defense must decide whether to continue testing limits. The prosecution must present its case with precision, and the jury must continue showing up, absorbing it all, and forming impressions that no motion can erase. This is no longer just about guilt or innocence. It's about whether the judicial process can withstand being treated as a stage rather than a forum. And the answer to that question will be shaped not by pundits, not by tweets, not by rallies, but by what happens next inside that courtroom, under oath, on the record, with consequences attached. Because at the end of the day, courts don't run on outrage. They run on procedure. And procedure, when enforced, has a way of outlasting spectacle. What we are watching now is whether enforcement holds, and if it does, this attempted walkout will be remembered not as defiance, but as the moment the limits became visible again.